Welcome to Looking at Legal Stuff. Today we have two hearings with a couple who recently split up, and now Mom is looking to have a DNA test done on their baby after she decided that he isn't the baby's father after all, despite both of them signing the affidavit of parentage. She's decided that her ex was in jail when the child was conceived. Let's see what the referee thinks.
All right, we'll take up file 2023-58926. This is the matter of Austin Sicard and Tessie Powers. Both are here, it looks like, via Zoom. Ms. Powers, is that you?
Yes, it is.
And Mr. Sicard, I saw you for a bit. Now you're gone. Are you still there?
Yeah, I'm here.
Oh, all right. And then Ms. Korndike is here. Ms. Korndike, who do you represent?
I represent Mr. Sicard. We just got retained on Friday, so I haven't had a chance to do an appearance yet.
All right. All right, and this is the date and time set for a hearing on Mr. Sicard's motion. He filed that on his own before he hired counsel. I guess, Ms. Korndike, do you want to explain what's being requested and why today?
Yes, Your Honor. My client also filed a summons and complaint to go along with this. Essentially, the parties are no longer in a romantic relationship and there is a child involved. So my client is requesting some temporary custody orders to be put in place at this time until the case can be resolved. Because at this point, since the parties are no longer together, there's no agreement on custody and parenting.
All right.
May I speak yet?
Sure, go ahead.
Can I speak?
Yes, go ahead.
I did not get this paperwork until Thursday, and my lawyer is not back until Mr. Guerrier is not back until Monday, and he told me to ask for it to be adjourned until he gets back.
So you hired Mr. Guerrier?
Yes, I did, and he is on vacation, as you know, until Monday, the 8th, and I'm to see him.
I don't know that he's on vacation. I mean, I'll take your word for it, I guess, but
his lawyer or his office just told me to tell you that.
Oh, okay.
Your Honor, if I may, I will, for the record, state this, that my client did file this on his own. I also agree that there's probably not proper service here. He did not serve under the timelines, and he understands that because we talked about that. Oh. So I do believe that she is entitled to an adjournment with this case. I don't know about Mr. Greer being on vacation, but definitely not proper notice.
All right. I don't mind adjourning this a week. I mean, but before I do that,
can I ask a question?
Well, hold on. Before I do that, though, I guess I want to know what's happening with the child at this point.
My son is with me. We had a domestic violence. My 9-year-old watched him punch me in the face and rip me around by my hair. My son got hit in the head with a car door. There's an open CPS case against him right now because of it. I do not feel comfortable with him going with him until after everything is actually said and done.
All right, Korndike, what did your client want to say?
He can speak freely, Your Honor.
What do you want to say, sir?
Well, as far as the CPS case, I was already cleared by Jason, the CPS worker. He said that I am more than capable of being around my son. He has no fear for my son's safety if I'm around. It's been almost a month already. I haven't been able to see my boy, and it's time. I mean, if we adjourn it, I'm okay with it, but I would like to have some kind of visitation. I would like to be able to physically see my son, see that he is okay. I have not gotten a single update or anything, and I would like to know, that he's okay. I would like to hold my son and see him. I've been in his life this whole time, and
He's
now all
not
of a
your
sudden
son.
he's ripped away from me.
What'd you say, ma'am?
He is not his real father. With Mr. Greer, we are trying to get him off my son's birth certificate. His real father is willing to be on his birth certificate. That is what's going down. He is not his real father.
So how was paternity established?
It was never established. I let him sign the birth certificate.
Well, that establishes paternity.
Well, Mr. Greer said that we might be able to fight that because his real father is willing to take a DNA test.
So so did you know at the time that he wasn't the father?
He knew. He was in jail when I got pregnant. He even knew it wasn't his son.
So you both signed that paperwork knowing at the time that it was false?
Yes.
The biological father wanted
you signed that under oath. That's a form of perjury, which is a felony if you sign that paperwork knowing that it's false.
Well, then I guess I'll have to deal with that. I did what I did, and I need to make things right for my son.
I mean, I'm not a cop. I don't monitor that stuff. I'm just telling you that it's potentially a felonious act to sign those documents under oath, knowing that it's false. So I don't know. How old's the child right now?
He's perfect.
I didn't ask. How old is? I said, how old is he?
Oh, he's a year and a month. He turned a year on the 8th, the day before the assault happened.
Uh-huh. And then were you guys together for most or all of that year?
Yes.
I've been in my son's life since before he was even born. I have taken care of him every day since he was born. That is my son. I named him. I raised him. He is mine.
You haven't had any parenting time for a month now?
No, she's neglected it because we have no contact. And then after I was cleared by the CPS worker on a Friday, it was
I've not been aware of that.
My stepmom and my dad were supposed to go meet up with Tessie to pick him up for a couple hours so I could see him. And she bailed because she says that I was going to steal him and not give him back. And that's not the case. I just want to be able to physically see, love, and play with my son. That is it.
So why is there a no contact order?
Because of the domestic violence.
Is that no contact order put in place by a district court order?
Yes.
Condition?
Yes.
Yes, Your Honor, Judge Drake.
So you're facing some criminal charges then?
Well, I'm going to be doing 6 months probation, and then after the 6 months, it's going to be dropped.
6 months probation. So you've been found or pled guilty to some crime?
No, that's in a month. That'll be in a month when I go back to court.
Your Honor, our office represents him on the criminal case too. He was given the offer of 7694A, the diversionary statute, that if he completes everything he needs to do, it's not going to be on his record. It's my understanding, Mark represents him on that case, but it's my understanding that he is going to accept that offer.
All right. So Ms. Powers was not inaccurate when she said that there was a domestic violence?
There was definitely an argument. I think that my client is taking the offer because it's a good offer. If he stays out of trouble, he's going to be pleading no contest to that. So we're not necessarily stating that all of the allegations that are in the police report are true, but enough to sustain the plea.
All right. Well, at this point, due to the fact Ms. Powers is requesting adjournment to have counsel and the fact that she likely wasn't properly served. I don't have a proof of service in the file, so I don't know what day it was mailed out, but Ms. Thorndike has indicated her client would agree that service was not proper. I'm going to adjourn the matter. There would be no interim order at this point because of the lack of service more than anything. Like I said, I can put this on a week from today if that works for everybody. Ms. Powers, is your attorney going to be back in a week?
He will be back on Monday on the 8th.
Okay.
Actually, Your Honor, Mr. Greer has a Social Security hearing that day. I'm covering for him on other matters, so he will not be available on Monday.
They called me and rescheduled for the 8th. So I had an appointment with him on the 9th, and they called and said that he was going to be back on the 8th and he could see me.
He can see in the morning, but in the afternoon, he's going to be in a Social Security hearing. I just talked to his office this morning.
Oh, I got it. I got any time that day, so I can put it on in the morning.
I am actually out of the office in the morning that day, unfortunately.
What day is John actually going to be back? Do you know? I got time on Friday. This Friday.
As far as I know, he said the 8th is the day he was going to be back.
Okay, so. May 12th, that Friday, I got any time in the morning.
I'm available, Your Honor.
All right, let's put on 9 o'clock on May 12th. I'll see you guys back here then.
Okay, and then I have something to discuss with you just briefly about the other case for this afternoon.
Oh, a different case? All right.
Yeah.
So folks, you'll get an order in the mail adjourning this until May 12th at 9 a.m. All right?
All right.
All right. We're all
Thank you.
set for today on this. Yep. All right. We'll take up file 2023-58926. Austin Sicard and Tessie Powers both are present with counsel. Ms. Smolders is here on behalf of the plaintiff, Mr. Greer on behalf of the defendant. This is the date and time set for hearing on a couple of things. Mr. Sicard had filed a motion regarding custody, which was adjourned because he hadn't properly served the other party, and she wanted to hire a lawyer, which she has now done, and this matter was set for hearing today. The defendant also filed a motion to establish paternity and essentially request indicating that Mr. Sicard was not the biological father of the child, although the parties have, it appears, executed an affidavit of parentage. Although that was not attached to your complaint, sir, and it says in the complaint that it is.
Sorry about that.
I don't have a copy of it attached to your complaint. However, I don't think it's in dispute that an affidavit of parentage was executed by the parties regarding the child, Damien. But now Ms. Powers has filed a motion to, I guess, revoke that. I think some things are agreed to moving forward. One is that the matter would be adjourned for evidentiary hearing on June 8th at 8:30 regarding both motions. To get to that part and to order a DNA test, though, Mr. Greer, I'll swear your client in. Ma'am, do you swear or affirm any testimony you give in this cause would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you need to speak right up. And your attorney drafted a verified motion to establish paternity and filed that with the court on May 15th of this year. Are you familiar with that document?
Yes, I am.
All right, and you signed that document on May 9th, correct?
Yep.
Pardon me?
Yes, I did.
Okay. And in order for that motion to proceed to a DNA test and an evidentiary hearing based on the results of that DNA test, there are certain additional things that were not in the affidavit that have to be explored. And I would note that I sent the Revocation of Paternity Act quick reference materials to both lawyers so that they had those. So we don't deal with these a ton. Mr. Greer, your client's under oath here. Why don't you ask her some questions to establish the requirements that the court has to find before it can be moved on to a DNA test.
Thank you. Tessie, you filed a motion for DNA test, right?
Yes.
To set aside the affidavit that he and you signed, correct?
Right.
And now you're asking for it to be set aside, correct?
Yes,
Why is that?
because I had mistake of fact
Okay, what would the mistake be?
that I thought he was the father, and I went back and it doesn't add up.
So you did the math, went
Yes.
back 9 months
Yes, I did.
to a conception time,
Yes.
and you think he was where was he then?
Jail.
So he was in jail at the time, you think?
Yes, he was.
All right. And so now you're asking because of that to set it aside.
Yes.
All right. Makes sense. That's all I have, Your Honor. I think you only need one of them.
Ms. Mulder, do you have any questions regarding that?
Yeah, I have a couple questions. So what was the date that your child was born?
On the 8th of
And
April.
okay. And do you know what your due date was when you initially discovered you were pregnant?
No, not exactly. I didn't. They helped
Okay.
me. Doctors are the ones that helped me figure out my conception.
Okay. And do you know if your child was born early or late or on the due date then?
He was born on time.
Okay. But how do you know that if you don't know what the due date was?
Because the doctors are the ones who told me what day I had to have conceived him.
All right. And when did you seek this advice from the doctors?
Yes, because I didn't know who the father was at the time, and he knows that too.
No, I asked, sorry, when did you seek this advice from the doctors?
When I found out I was pregnant, and I went and got established with a OB.
Okay, so you found this out when you found out you were pregnant. So why did you sign the affidavit of parentage indicating that the plaintiff was the father?
Because at the time I thought he could have been.
Mhm.
Okay, no further
It was
questions.
close.
Yes.
Your Honor, I don't have anything else. I don't know.
All right. I'm just looking this over. So, well, all right. I guess based on mistake of fact, I'll move this on for a DNA test. Parties would both appear along with the child on Tuesday, May 30th. At what time?
My understanding is on Tuesday,
Oh.
May 30th, they just have to all, submit to the DNA test that day. I don't think that they all have to be there at the same time. My client's work schedule.
I think they do have to be there, Val. I don't mean to interrupt you.
Oh,
Well, if there's a domestic violence, there's probably a no contact order. So,
Okay.
sir, what time can you be there on Tuesday, May 30th?
I can be there at 4 o'clock.
4 p.m. All right.
Is it open at 4?
I think she's open till 5 or 6.
Okay, good.
Ma'am, can you be there at say 3 o'clock so that you and the child are both tested and then you're out of there before he gets there?
Yes, I can.
All right.
Okay, so she's got to be there by 3, and then Mr. Sicard has to be there by 4.
All right. And
Okay.
and mom, this will be done at mom's expense. We'll reconvene on Tuesday, June 8th at 8:30 to consider the results of that DNA testing and for
You mean
either side,
Thursday, right?
Thursday, I'm sorry.
Yeah, okay.
For either side to provide testimony that would be necessary for the court to consider taking action as a result of the DNA test. Obviously, if it's determined that Mr. Sicard is the biological father, there probably isn't any basis upon which to further consider that motion. If it is determined that he's not the father, the court does not automatically enter an order vacating affidavits of parentage. There have to be findings made by the court based on evidence presented regarding the Revocation of Paternity Act child's best interest factors. They're a little bit different than the Custody Act best interest factors. The court doesn't automatically enter those orders absent testimony being presented regarding those factors. So that'll be on June 8th at 8:30. Mr. Sicard's custody motion would likewise be adjourned to that same date and time for evidentiary hearing on that. In the meantime, Mr. Sicard would have parenting time this Saturday from 10 to 6 and Sunday from 10 to 6 and Tuesday and Thursdays from 6 p.m. till 8 p.m. That would be supervised by his parents or Jeff and Crystal Wallace. When I say supervised, I call this a soft supervision. There don't need to be constant eyes on, but the supervisors have to be present in the vicinity of Mr. Sicard and the child to ensure the child's safety. They can go places together with a supervisor to parks, playgrounds, things like that. I know the child's pretty young, but that would be the parenting time going forward that Mr. Sicard would have pending hearing on the June 8th, as I indicated. There's been a drug testing order being entered concurrent here too to the other order. It's a reciprocal drug testing order. Either party can pay for a test for the other party, and the other party would have to appear for a drug test. Normally, that would be within 48 hours. However, if a test is paid for today, then the other party would have to appear before 5 p.m. today to supply a sample.
So we have 48 hours?
Normally you will, but for today's purposes, if a test is paid for today.
Why is that any different?
The 48 hours is designed to not unduly inconvenience a party with notice out of left field that they have to appear for a drug test, anticipating that not everybody may be able to drop everything and be there. Your client's already just 15 minutes away. If Mr. Sicard wants to pay for a drug test today and have her tested, she can be here from your office in 15 minutes. So I'm not finding that there would be an undue hardship for her to be here yet this afternoon. Mr. Sicard, is it your intent to pay for a drug test today?
Yes, sir.
What type?
Hair follicle.
When are you going to do that?
As soon as we get done here.
All right. So, Mr. Greer, you might as well just send your client up here. If it turns out that drug test has not been paid for by the time she gets here, I would consider reimbursing her for her time and the inconvenience of having driven up here from Fremont, but he indicates he's going to pay for that test, and that would be done today. Likewise, if your client wants Mr. Sicard tested today, I would have him appear and provide a sample today as well.
Thank you, Your Honor. We'll leave that option open. What about parenting time tomorrow? Where are we meeting? What are we doing here? We can't, obviously Mr. Sicard can't pick the child up because he can't be around her.
Can I just interject, Your Honor? I know this is unconventional, so I apologize ahead of time. Is Miss Korndike in the waiting room?
Oh, she is, yep.
Is there any way that, I know we've kind of agreed to all of these terms. This is kind of miscellaneous at this point. The parenting time exchanges and whatnot. I have a 12:10 that I have to be at. Is it possible to let her in and then she can take over with coordinating those exchange locations?
Yeah,
why don't you just order? I mean, we don't know who's doing the supervision yet, so.
Yeah, we do. We just stated all of those 4 people.
Well, there's 4 people, Val. Which one's doing it?
We don't, like I indicated,
we don't know, right?
We haven't been able to talk to those people because I asked my client just this morning to give me names. So out of those 4 people, I don't think he needs to pinpoint which one is going to do what day, but out of those 4 people, he can pick and choose based on availability.
Judge, can we have a day? I mean, I don't know why my client's having to do the transporting anyway. She's not going to get beat up.
The supervisor will coordinate the pickup and drop off with the defendant, with your client, Mr. Greer.
Do they have they got your phone number?
They should, yes.
Okay.
Does Austin have it?
Yes,
And
ma'am.
one last thing
Hey, Austin,
before
you got her phone number. You can give it to the supervisors to call her, okay?
Yes, sir.
Okay, thank you.
One last thing,
Good.
Your Honor, and I'll let Stephanie take over on this. My client has indicated he has a conflict on June 8th. So if Stephanie, you want to go through the schedule rather than having to adjourn after we get off, I'd rather, handle that issue right now if possible.
Oh, June
He
8th.
says he's not available till 4 o'clock that day, which I know I am available at that time if it can be changed.
To 4 o'clock?
That won't be enough time though. If we're taking testimony on those best interest factors and his custody motion and all that, I had the whole morning I was gone.
Got it. All right, I'm
Um,
going to log off and Stephanie, you take care of that, okay? Just that
Okay.
scheduling conflict.
Yep.
All right,
Thanks,
thank you. Yep, thank you.
Call
Sorry,
me
you guys.
about Dieters, please.
I'll tell her that, John.
Thanks, Val, or Stephanie, I appreciate it.
Yeah, no problem.
I got the morning of the 15th, the next week, if that works better.
Okay, hold on. Let me look. Are we talking about June, Your Honor?
Yes.
Good for you.
I work at night, so it's
Okay.
not good for me.
All right.
Yes, that's available, Your Honor.
All right, June 15th, 8:30 then, should be good. I think that takes care of everything. Was there anything else?
I think that takes care of everything.
All right, good. I'll do that order and have it faxed over to Accurate Screen, so she'll be prepared if people start showing up.
Very good.
All right.
Thank you.
All right, yeah, thanks. We're all set.